Mr. Baby Boy himself, Tyrese Gibson, has recently filed a lawsuit along with two other plaintiffs against the Home Depot Corporation. They're alleging that the Home Depot Corporation discriminated against them on the basis of race. Let's have a look.
I really struggled with even filing the lawsuit because Home Depot has literally been my favorite place. It's like my Disneyland.
So the lawsuit takes place in Los Angeles, California. And as you can see, it's a two-count complaint for violation of the Civil Rights Act, the California Civil Rights Act, and for negligent hiring, supervision, and retention. So we're going to be looking for both of those claims and the allegations to support them in the complaint. The defendants here are the Home Depot Corporation and 10 unnamed John Doe or Jane Doe defendants. This is done when the plaintiff doesn't know the actual names of the defendants, or the named defendants, their names should not be included in the complaint because the plaintiff desires to protect the named defendants, but that's usually only done in the case of minors. The plaintiffs in this action are not only Tyrese, but also two other individuals, Eric Mora and Manuel Hernandez. So let's see what they have to say. Looks like they start off with some rote allegations here. The Home Depot reported 160 billion in sales in 2022. Despite the success, discriminatory mistreatment and consumer racial profiling persist in its stores. Just so you're aware, Home Depot has been the subject of numerous employment discrimination lawsuits. Now, with respect to customer discrimination lawsuits, those are typically going to be a little bit more state specific because federal laws don't as easily get to customer-based discrimination in the context of consumer transactions. You kind of have to fit those into federal laws a little more with a little more nuance. But where there is a specific state action for discrimination against businesses, for discrimination in consumer transactions, then you're going to see a lot more of these discrimination lawsuits. We don't have those types of acts here in Florida, so you're not going to see these types of cases as much here in Florida as you are in say, California. But moving on, Gibson, one of the most recognizable black actors and musicians in the United States. Okay, Tyrese, I give it to you. You know, I've been down since Baby Boy. You know, I was with you when you were doing Signs of Love Making, and you know, you're pretty recognizable. I just want to know, when you say one of the most recognizable, how many are we talking about here? Like, are we talking like top 5, top 10? Because I mean, I can rattle off a few, you know, black actors / musicians. You got Will Smith, Jamie Foxx, John Legend, Ice Cube, LL, Common, T.I., Snoop Dogg. I mean, the list goes on. It's a pretty extensive list. I just want to know, where do you think you are on that list as far as, you know, the amongst the top? But, you know, you do have some bangers out there. You got the Transformers movies, and you got the Fast and Furious movies, and of course, you have Baby Boy. So, you know, you got a lot of acting credits, and though you haven't dropped an album in a while, you know, you are still a recognized musician. So I'll give it to you as one of the most. I just want to know how long the list is. His associates, craftsmen Mora and Hernandez, experienced outrageous discriminatory mistreatment and consumer racial profiling firsthand inside the Home Depot in West Hills, California. When the plaintiffs attempted to make an in-store purchase, store clerks purposely interfered with and refused to process the transaction based on their groundless suspicion of Gibson, Mora, and Hernandez arising from their skin color, and in the case of Mora and Hernandez, their national origin as well. The Home Depot has refused to take any responsibility for discriminating against Gibson, Mora, and Hernandez, or to acknowledge the pain, humiliation, and anguish caused by the company. Instead, the Home Depot doubled down, lawyered up, and treated them and what happened that day as not worthy of any due consideration. Gibson, Mora, and Hernandez are taking a stand against the Home Depot to hold it accountable. The company needs to understand that there are consequences for discriminatory mistreatment and consumer racial profiling. So none of these allegations really get to the heart of the matter. But he goes on to kind of describe the act under which he's suing here. We're just going to read a couple sections there. Under the act, which is called the Unruh Civil Rights Act, potential plaintiffs are entitled to the full and equal accommodations, advantages, facilities, privileges, or services in all business establishments of every kind whatsoever. That is worlds apart from the statutes we have down here in Florida. Whoever denies, aids, or incites a denial or makes any discrimination or distinction contrary to Section 51 is liable for each and every offense for the actual damages and any amount that may be determined by a jury or a court sitting without a jury, up to a maximum of 3 times the amount of actual damage. So the cause of action provides for essentially what's called treble damages. Anytime you see 3 times the amount, lawyers speak for that as treble damages. They go on still talking about the Unruh Act, but this is case law. A business establishment's unequal race-based treatment of its customers is unlawful under the Unruh Act, even if its customers are not denied services. So you can have a discrimination occur even where the customer is able to enter into the transaction. And that's why I said this is a little different than federal causes of action. Typically under a federal cause of action, unless you're denied services or denied the ability to enter into the contractual agreement at a retail establishment, then your ability to maintain a cause of action is pretty slight. This is true whether the discriminatory treatment is verbal, physical, or financial. Thus, in the context of alleged racial discrimination, the dispositive question under the Unruh Act is whether the plaintiff faced unequal treatment on account of his or her race that members of other races did not experience. So that's interesting under this Unruh Act. The question being, did the plaintiff face unequal treatment that members of other races didn't experience? That sounds like what is called the Comparatory Test, meaning in order to prevail on a claim, what it sounds like here, and I'm not familiar with the Unruh Act or the case law around it because I'm in Florida, not California, but what it sounds like is you're going to have to show that others of a different racial or ethnic group or of a different national origin didn't experience the same treatment. Now, you can do this by actually having those people come in and testify. You can do it with video cameras. Now, in this case, we're talking about use of a credit card. So if they have to have a comparator analysis here under the Unruh Act, you would probably have to find typically white patrons who were allowed to use a credit card without question as to whose credit card it is. So if white people were able to use credit cards and they were not asked for either their ID or some other identification to use the credit card, then that would be a good comparator for Tyrese to use. Moving on. So we're under the parties, jurisdiction, and venue section. And here they talk about the Jane Doe defendants. And they basically say that they don't know the names of the Jane Doe defendants, or John and Jane Doe defendants. But they go on, plaintiffs are informed and believe and based thereon allege that defendants in each of them were the agents, employees, partners, joint venturers, co-conspirators, owners, principals, and employers of the remaining defendants. And each of them and are, and at all times herein mentioned were, acting within the course and scope of that agency, partnership, employment, conspiracy, ownership, or joint venture. Plaintiffs are further informed and believe and based thereon allege that the acts and conduct herein alleged are of each such defendant were known to, authorized by, and or ratified by the other defendants and each of them. So what it sounds like they're alleging here is that all of the defendants together were co-conspirators. So they kind of had like an agreement, I guess, to engage in the discriminatory conduct. It's a little confusing because it says that they were employers of the remaining defendants, but they're talking about all the defendants already. So it's a little confusing as to who exactly they're alleging is involved in this alleged conspiracy. Because they're obviously excluding some of the defendants, but they're also including all of them. So yeah, I'm a little confused. Moving on, plaintiffs are informed and believe and thereupon allege that at all relevant times defendants acted in concert, conspired, and agreed among themselves to commit the wrongful acts and practices alleged in this complaint, and that such wrongful acts and practices were committed pursuant to and in furtherance of such conspiracy and agreement, and with the consent and approval of each of the defendants. Plaintiffs are informed and believe and thereupon allege that each of the defendants are liable as a direct participant, co-conspirator, and or aider and abettor of the wrongful acts and practices alleged herein. So essentially, it looks like they're trying to cover all their bases here. Either they were directly involved, they were a co-conspirator, or they aided and abetted the discrimination. So all of the defendants, they're saying, are somehow involved. Let's get to the facts. Gibson, Moore, and Hernandez were subjected to outrageous discriminatory mistreatment and consumer racial profiling. That's not a fact. So we can disregard that. On the evening of February 11th, 2023, Gibson, Hernandez, and Mora approached the cashier's register together to complete the purchase of materials for an ongoing project at Gibson's residence. Gibson is a longtime customer of the Home Depot, and over time he has purchased no less than $1 million worth of materials from the company. Mora and Hernandez regularly provide construction services to Gibson in connection with his projects. In this capacity, they have patronized the Home Depot, particularly the West Hill store, on many occasions over the years. So it looks like if Gibson has done over $1 million worth of purchases from Home Depot, particularly from the West Hill store, either they know him there and or they know Moore and Hernandez there. That seems to be kind of what he's getting at, but he doesn't explicitly say that. So that calls into question whether he actually believes that to be true. And I would say it falls on the side of he probably doesn't believe that they actually know him, or that they know Moore and Hernandez and that the three of them are somehow affiliated. So if they saw them on the street, they wouldn't recognize them as being affiliated with each other. The cashier was very slow scanning items, and the process took 20 minutes. So my question would be, how many items did you have? Because 20 minutes seems like a long time, but that depends on how many items you were purchasing. Then the cashier insisted that all items be rescanned because of a purported glitch in the system. While the cashier reran the scanning of the merchandise, a process that extended another 20 minutes. So if it was 20 minutes the second time too, that would kind of lead me to believe that you just had a lot of stuff. Gibson was approached by shoppers who recognized him from his roles in motion pictures. That's believable. Not wanting to create a disturbance in the store with his fans, Gibson decided it would be better to wait in his vehicle, which was parked outside. That's reasonable. Gibson communicated to the cashier that he would proceed to the parking lot and that Mora and Hernandez would be completing the purchase transaction with his credit card. Okay, so he told the cashier, I'm going outside, but these two guys are going to complete the purchase with this credit card. The cashier acknowledged and said he understood. Okay, so the cashier is saying, I understand that Mora and Hernandez are going to complete this purchase with the credit card that you just gave them. Gibson asked the cashier if the cashier needed anything further from him to complete the transaction. So Gibson asked to make sure that everything was copacetic. And the cashier said no, and that Gibson could leave. So not only did the cashier say no, but he also, according to this, told Gibson that Gibson could leave, which is tantamount to him saying you can leave and this transaction will continue with the credit card that you just gave to Mora and Hernandez. So all of this is a pretty important allegation. There's a lot in it, but it's a very important allegation. However, when Mora and Hernandez presented Gibson's credit card to pay for the materials, the cashier refused to complete the purchase transaction. Okay, so they're saying the cashier acknowledged that Mora and Hernandez could use Gibson's credit card to pay for the materials, and then refused to complete the transaction once Gibson had already left. Mora and Hernandez called Gibson using Facetime and passed the phone to the cashier. So now the cashier has their phone. Gibson, appearing on the video, again authorized the purchase transaction. So the cashier just saw Gibson in the store. Gibson told him he's going out to the parking lot. He told him these guys can use the credit card. He's now on a FaceTime video. And realize you're on a FaceTime with Tyrese Gibson, you know, Transformers, Fast and the Furious, Sweet Lady. You're on a FaceTime with him. He was just in your store. He's saying, let these people use the credit card. You know, the one that you just said you would let them use when I was standing inside the store in your face. And despite this, the cashier continued to refuse to complete the transaction. Okay?
Do you have a pro account?
Ma'am, should I have the CEO of Home Depot to call you tomorrow? Because he's my neighbor. He's my neighbor in Atlanta. You want me to get the CEO of Home Depot to call you and tell you that this is unnecessary, what you're doing?
Yep, my manager said that's fine.
Okay, tell your manager I was just in the store. Do you want to tell him that part?
He can hear you.
Okay.
Gibson returned to the inside of the store, again authorized payment, and asked why the cashier refused the transaction. Gibson also asked to speak with the store manager. The cashier gave no reasonable explanation other than repeating store policy and demanded to see a form of identification. So now he's asking Tyrese to identify himself. He's not self-identifiable. So this is probably where we're getting into a bit of a problem, because I doubt that they ask everybody for ID when they're trying to use a credit card. But to ask Tyrese Gibson for ID when you're using a credit card, when you don't usually ask for ID to use a credit card. I mean, I can't remember the last time I was asked for ID to use a credit card anywhere, and I shop at Home Depot. So you're asking for the ID of a celebrity who's immediately recognizable. After you saw him give these guys the credit card. Okay, so something is wrong here. I don't know if it's racial discrimination, but something's definitely wrong here. Okay, so the manager refused to speak with Gibson in person. Okay, so manager doesn't want to talk to him. The guy that has spent $1 million at Home Depot. The manager doesn't want to talk to him. It was only after significant heated discussion with the cashier that Gibson was finally able to complete the transaction. So in order to complete the transaction, he had to have, by significant, I'm assuming that he means long, drawn out, things of that nature. Heated, that probably means they were yelling at each other. A significant heated discussion. So that's an argument. That's what that is. That's a long argument. After a long argument with the cashier, Gibson was finally able to complete the transaction. So under the Unruh Act that we just read, even though he was able to complete the transaction, they held him up from completing the transaction, and there doesn't appear to be much of a reason for it other than just saying, well, it's store policy. And there probably is a store policy that says, well, anytime somebody wants to use a credit card, you have to ask them for ID. In fact, I think credit card carriers require the stores to ask for ID in order to complete transactions. I think that's the case. So these stores have probably codified that into their store policies and procedures, but what stores really do it? So it doesn't matter what the policy says if you're always breaking the policy. If it's the custom of your business to break the policy, to not enforce the policy, then it doesn't matter what the policy is, because it's as if the policy no longer exists. So just repeating store policy doesn't cut it. The actions of the cashier and manager were discriminatory based on race and origin. There is no other plausible explanation for the mistreatment of plaintiffs. So, the actions of the cashier and manager were discriminatory based on race and origin. This sounds like a very big inferential leap. Because there was some mistreatment, because they did something wrong, we automatically jump to race and national origin. But it's not a big inferential leap as far as the law is concerned, because of what they say in this second sentence. There is no other plausible explanation for the mistreatment of plaintiffs. So, what they're saying is, Home Depot Corporation can't come into court and give a plausible explanation as to why the customers were treated this way. Now, if such a plausible explanation exists, then the claim fails. But barring such plausible explanation, we can only assume that the explanation is what the plaintiffs allege it to be. So when you're looking at this case, I've seen a lot of comments to a lot of articles about this case, basically saying, yeah, so you were asked to use to show ID when using a credit card, and so that must mean that you were racially discriminated against. But yes, because no one's asked for a credit card when they're trying to or an ID when they're trying to complete a credit card transaction. The times that happens are so few and far between that for somebody to be asked for an ID, especially a celebrity, because remember, he came back into the store and was still asked to produce an ID. For a celebrity to be asked for an ID after the store clerk has already said it's okay for you to proceed with this transaction with you outside and me and these two individuals whose credit card it is not, we can still conduct this transaction without you being here. For all of that to have taken place, and then you're still denied for an extended period of time the ability to complete the transaction, there's really no other plausible explanation that anybody can come up with as to why that's the case. So if Home Depot can't come up with an explanation, then we shouldn't assume that another explanation exists. So the complaint goes on. The transaction was refused despite Gibson's repeated authorizations because of plaintiff's skin color, and in the case of Mora and Hernandez, also because of their national origin. This is a clear and deplorable instance of discriminatory mistreatment and consumer racial profiling. The treatment of Gibson, Mora, and Hernandez by the Home Depot was humiliating and demeaning. So, this, based on these allegations, and there's only a few, there's only 5 factual allegations here, and 2 of them are not really factual. Based on the 3 paragraphs of factual information regarding a recounting of Gibson, Mora, and Hernandez's experience in the Home Depot, it seems to me that there is actually a legitimate case for discrimination under the California law here. So let's go down to the causes of action and see if there's anything here. So in order to bring a cause of action under the Unruh Act, these are the elements. You have to be of a protected class. There has to be a business establishment. There has to be discriminatory business practice, and there has to be discriminatory intent. Gibson is black. Mora and Hernandez are Hispanic of Mexican national origin. So we have the protected class. Home Depot is definitely a business. So we have a business establishment. On February 11, 2023, defendants subjected plaintiffs and each of them to a discriminatory business practice with discriminatory intent when refusing to or otherwise preventing plaintiffs from completing their purchase transaction at defendant the Home Depot's West Hills retail store as described above. So we have the discriminatory business practice and the discriminatory intent. A substantial motivating reason for defendant's conduct was defendant's perception of plaintiff's race, color, and or national origin. So we have a second cause of action here. This is brought by all plaintiffs against all the defendants. So this includes all of the Jane and John Does out there. Defendants hired and retained the cashier and manager, collectively the employees, were present at defendant the Home Depot's West Hills retail store on February 11, 2023, and who subjected plaintiffs and each of them to a discriminatory business practice with discriminatory intent when refusing to or otherwise preventing plaintiffs from completing their purchase transaction as described above. So my confusion, the reason you see confusion on my face is because he's saying that all of the defendants are in this cause of action, and the defendants hired and retained these 2 employees, the cashier and the manager. The cashier and the manager subjected the plaintiffs to the discriminatory business practice with discriminatory intent. So that would tell me that these 2 employees, the cashier and the manager, are part of the prior cause of action. Which is also all plaintiffs against all defendants for violation of the Civil Rights Act, because they're the ones that did it. But if those employees are included as defendants in this lawsuit, which we can't tell at this time because they're unnamed, but I would assume that they are, then all of the defendants didn't hire and retain the cashier and the manager. So the employees themselves should not be a part of this cause of action. So the cashier and the manager, maybe the manager, but the cashier definitely should not be a part of this cause of action because this is for negligent hiring, supervision, and retention. The cashier didn't hire, supervise, or retain himself. So this should not be against all defendants if the cashier is included as one of the defendants. So this is probably going to be subject to a motion to dismiss, or they're probably going to have to file an amended complaint just to clean that up. It goes on, the employees were unfit to perform the work for which they were hired. Defendant knew or should have known that the employees were unfit and or incompetent, and that this unfitness and or incompetence created a particular risk to others. The employees' unfitness and or incompetence harmed plaintiffs. Okay. Other than the inconsistency here, it seems pretty par for course. So let's see what they're asking for. They're asking for damages in an amount to be proven at trial, but believed to be in excess of $1 million. Okay. Statutory damages, attorney's fees, punitive damages, a declaratory judgment declaring that the Unruh Civil Rights Act applies to defendants and that defendants' actions violated the Unruh Civil Rights Act. So I don't know why they're looking for a declaratory judgment when they already have a cause of action that they're alleging in the complaint. So declaratory judgments are typically used to determine a party's rights in order to see whether or not they have a cause of action, or to determine a party's rights under a contract. So you can see a declaratory judgment action together with a complaint for damages where they're seeking a declaratory judgment as to a certain provision of a contract. So they're asking the court to say, please decide, court, please declare that this contract, this provision of the contract means this. And then they'll have a breach of contract action based on what they think the interpretation of the contract is. And then they'll try to get the declaratory piece resolved before the breach of contract piece is resolved. So if the court declares that the contract means what they say it means, what they think it means, prior to a trial on the merits of the breach action, then at the trial on the merits of the breach action, the jury is told what the contract means. But here, they're just asking for a declaratory judgment that the act applies and that they violated it. But that's the same thing they're asking for here, which is that the defendants violated the Civil Rights Act. So there's really no need for a declaratory judgment here that I can see. They also want pre-judgment and post-judgment interest, and of course, such other relief as the court may deem just and proper. So there you have it, folks. That is the causes of action that Tyrese, Eric Mora, and Manuel Hernandez have lodged against the Home Depot. So before you read some newspaper articles or watch videos regarding this lawsuit, please make sure you take a look at the complaint, because the complaint actually does make out a viable cause of action from this attorney's perspective. But let me know what you think in the comments below. Until then, my name is Nathan Saunders. This is The Legal Good, and I'm out.